This time I tried also another experiment. I used the camera connected to the computer in order to stream. So we'll use only that camera to maybe the quality of the recording is not as good as when the camera is offline, but we can optimize the flow of data this way. Plus, we record directly on the cloud instead of having the USB stick to be used to upload. So then I'll deal with that. So, okay, we are here for the second, let's call it the second event, the second meeting out of two. We'll go back to tax treaties. Yesterday, we have very broad talk, free talk on what is a tax treaty, what is a tax treaty for, how it's supposed to be interpreted. We also discussed a bit on tax planning or aggressive tax planning. You give us the case of the company in Saudi Arabia doing a business in the UK or United States, in Philadelphia, that's right, in Philadelphia. And then in order to optimize the taxation on the outgoing flow of interests, it was a loan. The company in Saudi Arabia incorporated a subsidiary in the Netherlands in order to make the most of the tax treaty between the US and the Netherlands, and in order to prevent in this way the withholding tax or tax at source. But with the tax treaty, there is much more than that, right? I mean, tax treaties deal with cross-border payment of dividends, of royalties, of interests, of course. But tax treaty also deal with, we discovered that yesterday, on the residence of individuals and of companies. Treaties do not tell you when a company is resident in one country or in another. But the treaties tell you, well, when a company is deemed to be resident in both the countries, or a person, a natural person, is deemed to be resident in both of the country, which country should prevail? And this is also important because, normally speaking, in most of the situation, in many cases, as Professor WIjnen pointed out, residence is a criterion to be considered as to where are you supposed to pay taxes. This is very true for business. I mean, if you have a company, if you are an entrepreneur and you carry on your business activity in one country, in one state, normally you pay taxes, of course, on your profits in that, your profit, if any, of course, in that state. Even if you are making profits in another jurisdiction. For instance, you are resident in Italy, you're selling products in other states, you're making money. Those monies are taxable in Italy and in Italy only, not in the source state, because business income, Article 7 of the OECD model, provides for that. But there are exceptions to these rules, right? There are situations where a business is liable to tax also in another jurisdiction.
Yes. Well, yeah, indeed, a company is taxable exclusively, as you pointed out, exclusively taxable in the resident state. So if you take a company here in Ferrara, it is not only taxed for its profits made here in Ferrara or in Rome or in the Netherlands or in China, whatsoever. The income of the business income of this company is exclusively taxable here in Italy. And tax treaties are very, very keen on that. If you look into the OECD and the UN model, they use all the same wording for that. They use, for such an exclusive right to tax, the term shall be taxable only. Well, tax treaties, we saw it yesterday, are dealing with two countries, country A and B. They are bilateral agreements. And if a company is located in state A, for instance here in Ferrara, the exclusive right is, through the formulation, shall be taxable only here in Ferrara. It solves immediately the problem. There are always two countries involved, A and B, but with an exclusive right to tax, well, the problem is solved. Business income is taxable in the resident state. Treaties do not leave any exception, only one. Because if the activities of the company here in Ferrara in state A take a certain substance in another country, then the other country may tax. Well, what is the substance? There is a term for it. It is permanent establishment. If you look into Article 5 of all the 4,000 tax treaties, the OECD model, the UN model, the Article 5 has a title, permanent establishment. Well, what is permanent? Yeah, you can look into a dictionary, you can look into philosophers, you can find a lot of information about permanence. Well, the permanence we are talking in this context is permanence in relation to an establishment. But then, we know what is an establishment, but what is an establishment in this context? And when is an establishment, when there is an establishment, okay, but when is it permanent? Well, there is there's a definition. The definition is included in the first paragraph of all of the two models and all 4,000 tax treaties. To avoid a mistake, I'm going to read it. This is very simple because, in fact, it is a one-liner. So it's not necessary to write it on a board or so. It is, in fact, a very simple provision. It starts as follows. It starts for the purposes of this convention. Well, that means that wherever you find in the tax treaty the term permanent establishment, it is this definition that is relevant. Well, I continue. For the purpose of this convention, the term permanent establishment means the fixed place of business through which the business of an enterprise is wholly or partly carried on. Do you know what is written here?
Like moving the real estate of the company, for example.
Sorry?
Moving the real estate of the company, or
Yeah, well, that is also very, what you now mentioned is also very general.
okay.
Yeah, but I'm not going to say no. I cannot say yes, but let us have a closer look at it. I reread now the sentence. The term permanent establishment means a fixed place of business through which the business of an enterprise is wholly or partly carried on. At first instance, I think, if you read it, now you hear it, but if you read it, at first instance, I think that's the way it went with me. I think, oh, that is simple. But once you have thought that, at second thought, said, my goodness, I don't know what it is. What is written here? It is so abstract. It is like the Oracle of Delphi. There is a Pythia and a curtain, and you hear this sentence. And then you have to go home and to find out what is meant. Frankly speaking, I do not know what is written here. It is so abstract that I don't know how it has to be translated to a factual situation. What is covered by it? Well, if I would not have any further information, I would not know how to deal with it in practice. But fortunately, there is a commentary to the OECD model, a commentary to the UN model, and there you find some further information. And what you find there are three elements in this definition. The first is, I reread it again for you, means a fixed place of business through which the business of an enterprise is wholly or partly carried on. There are three elements. First, what is a fixed place? Do you know what is a fixed place? What is a place of business? Do you know what is a place of business? I know it now after so many years. And what is a business of an enterprise is wholly or partly carried on? Yeah, today I know what it is, but I can tell you at the beginning I didn't know. Well, the OECD commentary gives an indication. A fixed place is is indicated as permanence on a distinct place. So the company in Ferrara, who is active, let's say in Spain, in Barcelona, he must be active on a distinct place in Barcelona. And that must be permanent. So not one day, but let's say a year, 2 years, 5 years. That must be permanent. So the OCD model gives, in respect of a fixed place, gives a further indication. Whether it is helpful, we see later. Place of business. What is a place of business? Well, that means that there must be physical presence of the company here in Ferrara in Barcelona. The company must be there physically present, such as having a building, machinery, or equipment, something visible. There must be something. A place of business. And yeah, the third element is business carried on. What is it? Business that is carried on. Well, production, trade, services. This is the help, the support that you find in the commentary of the OCD model and the commentary of the UBL model. Not more, not less. For the rest, you are left on yourself to find out what a PE is. The only thing that we can do now is to take a number of factual situations to see how it works out in practice. I cannot do more than that. I cannot philosophize more on these terms. They are abstract, and I can only give it, let's say, flesh on the bones. In Dutch we say hands and feet, by giving you some examples. So let us start with a very simple example. Let us start with a company here in Ferrara that produces shoes. In Italy, there are many shoe factories. I think Italy is the leading country in respect of the shoe business. Take a shoe factory here in Ferrara, and who has in Lucerno in Switzerland a building, and there are working, let's say, 1,000 employees, and they produce mountain shoes. Well, is that a permanent establishment? Let us go to the 3 criteria. Is it a fixed place? Do you say it's a fixed place? There's a building, big factory, the size of 2 football fields, 1,000 employees. It's a fixed place. Would you say it is permanent on a distinct place? If you say yes, if somebody says no, is there somebody who says that is not permanent on a distinct place? Then we must have a discussion. I think it is permanent and it is distinct. Okay? The place of business, what they are doing, they are producing shoes. So also that element is fulfilled. And then, is there a business carried on? Yes. Yes, there is production, services, whatsoever. Perhaps also the trade service, the trade of these shoes to customers. So we can say, here we have an example of a company here in Ferrara that has a factory outside of Italy, in Switzerland, and it is a permanent establishment. And that means that the profits made by this company here in Ferrara in Switzerland may be taxed in Switzerland. It may also be taxed here in Italy, but then Italy has to take into account that the profits made in Switzerland are already taxed in Switzerland. And there is a system for. In your country, you have in Italy a credit system, and that means that the tax paid in Switzerland can be deducted from the tax paid to be paid here in Italy on the Swiss income. Okay? We take another example.
Unfortunately, Italy is not that generous because in line of principle, it's like you said, but our domestic law provides for some thresholds to the credit that you can use in here unless the treaty is enforced. So yes, but that's very, very Italian situation, but I believe quite common in other countries. Yes, indeed, we recognize the taxes paid abroad, but if you pay in Switzerland, like, I don't know, 1,000, Italy do not necessarily recognize 1,000. It could be 900, 950, but, you know.
Oh, yes. Oh, yeah, the taxable income in Switzerland has to be valued on the basis of Italian domestic law.
Yeah.
And then there's another thing, and that is what we touched yesterday. It could be that the tax rate in Switzerland is higher than here in Italy. And then you are not going to give a credit for the full amount of the Swiss tax. So there are a lot of other issues relevant in this context, but we draw only a straight line to the notion of permanent establishment. If you are going to go to all the details, well, then we need
Sure, of course,
some weeks or months to discuss it. That is impossible. So I would like to give you only an idea what the notion of permanent establishment is. I give you another example. Let us take a computer company here in Ferrara and assume that this company sells to customers in Paris every month 1,000 computers, laptops. From here, the customers, they send an order to the company here in Ferrara, and through the post, these computers are sent to the customers in Paris. Would you say that this company has a permanent establishment in Paris?
No.
You say no?
I don't think so. I mean, they're not there physically. They don't have an establishment.
Yes, there's no establishment. There's no fixed place, not permanent. Yeah, perhaps these sales are already going on for, let's say, years and years, but there's no fixed place. Well, now we give a tick against the kaleidoscope. Now, the same example, but there is a shop in Paris, and the 1,000 computers are sold from the shop in Paris. There's also 3 employees, and they sell these 1,000 laptops through the shop in Paris. Is it then a permanent establishment? No. I think so. This is a fixed place. It's permanent. There's business going on. So all these 3 elements are fulfilled. Well, again, a tick against the kaleidoscope. Let us now take there's no shop in Paris, but every year in the week before Christmas, the director of this company in Ferrara goes to Paris. He rents always the same hotel room and sells in the week before Christmas 1,000 laptops from that hotel room. Is that a B?
I don't think so. Like, yeah, it's just seasonal thing.
Okay.
I think it's not permanent. Maybe he offers these services, but not like this.
You say, well, it is not permanent.
Yeah.
Once per year is not enough to make something permanent. Yeah, and any argument is valid. And let me be very clear. Okay, I take that point. Is something else?
Like maybe if he would rent the room for a whole year, like let's say 5 years in a
Okay.
row,
Mhm.
then we could like discuss. But when he's like renting it each year for a few days, then I don't think so.
Okay.
Logically, that comes to mind, but I don't know if since we don't have no clear definition, it can be argued. I don't know if it goes against like clear logic to say that there is no limit, there is no minimum. And what is a permanent establishment? Something that the company owns or leases.
Yeah, well,
Definitely.
I think we agree, all of us agree that permanence is in this case a relevant factor in this situation. And, well, is this distinct place a factor? It is. Well, it is always the same hotel room. What about a hotel room? Do you think that a hotel room can be a permanent establishment? Is it necessary that, for instance, that you own the real estate, or
Yeah,
is it,
I think so.
or is it good enough to rent it?
Maybe you can rent like
Okay.
a contract
Okay,
for
that's-
20 years. For example.
And if you would have, let's say, the use of a real estate and without owning it and without renting it, that you can only make use of it. Is that good enough?
Still have some kind of contract that is like that you are not going to pay for it, but still they are going to allow you to be there, so you have some kind of right to use that space.
Even if you may use a site without any right, it's only made available and you make use of it. Is that possible? Can that still make a permanent establishment? I think so.
It's about the perspective, like looking
Yeah.
outside, looking in, what you can
Yeah,
observe.
I can give you examples of that. So it's not, it's a simple side way. It's not necessary that you own the site. It is not necessary that you rent it, or everything is possible. Even the simple use can create a permanent establishment. So back to our hotel room. So the director is in the hotel room, and he sells once per year, the week before Christmas, from there 1,000 computers. Well, there's a trade, so there is business. That is undeniably true. There's a business. There is a distinct place, but I think it fails in respect of permanence. An hotel room in itself can be a permanent establishment. But then again, we changed the picture. Assume that this director goes there every month. Would that make the hotel room a permanent establishment? If you say no, then I say, well, he goes every week. When there is sufficient permanence?
Like for me, it would still be freedom of services and not establishment. And for me, like the freedom of establishment would start when most of his business would be in the other country or like the same amount, and not like that he only goes there once upon a time. And
I fully agree with that.
But let's say if he's, for example, doing this for many years, then he could have some kind of base of customers which are used to go there like each year before Christmas to buy new computer, new stuff to use with the computer.
Yeah.
So maybe the permanency could be in the base of the customers which are used to go there each year before Christmas.
Yeah. The customers. I think that is an original idea. The customers know that he is there in this hotel room.
Yeah, each year.
But yes, but it is still, that hotel room is only for 1 day per year a permanent establishment. I think permanency in this particular situation is not good enough. If you ask me when it is good enough, I must say I don't know. Yeah, if you would go there every week, no doubt. If you would go there every month, well, perhaps. If you would go there 5 times per year, well, it depends on other things. Then you have to take into account all kind of other things. So yeah, you could say, well, you can take also another picture. Assume that the director is a hotel freak and that he would go every time in Paris to another hotel. What about a distinct place? Is Paris in itself a distinct place? Would you say, well, Paris in itself is a distinct place? Is that possible?
It's a matter of perspective, you say.
Yeah.
Depends on the point of view that you take in order to.
Well,
And yeah, it's a matter of perspective. Subjective.
yeah. Well,
But
if you
like it depends, because
historically,
if I, for example, imagine some kind of buffet which is like in some kind of van, and he's moving all year like through the city because of some kind of events, or changing the squares to find new customers, then it could be like the permanent place. The whole city could be permanent place, but it depends.
yeah, I think that you should be very careful with distinct place. Distinct is a very specific term. Distinct is distinct, and you cannot extend it that easily. Paris, as such, as a distinct place, well, that is not accepted more or less in the notion of permanent establishment. I can give you quite a number of examples in this respect. There was a tourist company in London, and this tourist company sent in the course of the spring and the summer every week a group of tourists, 30, 40 tourists, to Istanbul, and then they were embarked in a boat, and then they were in the territorial waters a week in the bays, and then after a week they went back. And the question was, for the Supreme Court in Turkey, could you consider that the territorial waters of Turkey have to be considered as distinct? The Supreme Court in Turkey said yes. A bit strange. Extraordinary decision of the Supreme Court in Turkey. I've never seen something like that. It is not sufficiently distinct according to the general ideas about permanent establishment. So let me, if you like, I can give you a striking example of my own practice in the Netherlands Ministry of Finance. We had to do in the Ministry of Finance in the Netherlands with the specific problems in this respect of our tax inspectors. And one of these cases was very interesting. It had to deal with a fishmonger in the Netherlands. You know, we have in the Netherlands 2 big rivers, and they are ending up in a delta. And these deltas are full of eels, long fishes. And
They have eels here in Ferrara, I mean, in Comacchio, I guess.
And this, well, let us give him his name a name. His name was John Fisher, and he and his family, all for generations, were fishermen, fishmongers. And on Monday, the family and our John Fisher was used to go to the delta, and with a boat early in the morning, he caught the eels, he placed them in the boat, and then in the afternoon he went home and he smoked them in a wooden barn in his backyard. And so he did on Tuesday, Wednesday, and Thursday. On Friday, he took all the smoked eels in a van and he went to Belgium. And he sold these smoked eels all over the places in Belgium. Not in one place, but in summertime in Oostende, in Ghent, in Brugge, Antwerp, and all these places where the tourists were. There you could always find John Fisher selling his smoked eels. He did not sell one eel in the Netherlands. He did it only in Belgium.
Mm.
And once, on the 1st of August, there was a Belgian tax inspector with his family and 2 children, and he saw there John Fisher. They took each such an eel with a roll, with some bread, and said, well, it's delicious. The next Saturday, he said, oh my goodness, we are cycling, and we see John Fisher again on another place. And they said, well, it was a very good deal. We do the same. All the 4 members of the family bought and took such an eel. Same happened the 3rd Saturday of August. And then the 4th Saturday, after the last day of their holidays, the Belgian tax inspector said, well, John Fisher, I see that your name is John Fisher. I see that you live in Drimmelen in the Netherlands. And how is it? Are you only selling your fishes here in Belgium? Yeah, only in Belgium, not in the Netherlands. There are so many competitors, but I always find my place, the best places in Belgium. And so, oh, that's interesting. So the inspector had a pen, took some notes, telephone number, the address, email address, and so forth. And back in office, he sent a tax return to John Fisher. Because, in the opinion of the Belgian tax inspector, this was a permanent establishment. A van on wheels, it's movable, was considered to be a permanent establishment. What do you think of this?
It's a similar example as I mentioned with the prepared in Paris, that you are changing the place to attack more customers or just to get touch in different customers. So in my point of view, it could be a distinct place.
Okay. Well, you follow the Belgian tax inspector.
Yeah.
Yeah. Okay. Somebody else?
I think it should just be a technical idea, so it should be
Okay.
someday.
Some other views? I can tell you, John Fisher was not happy.
That's for sure.
No, he was furious. He said, the Belgians are out of mind. Forget them. Well, yeah, it became a long story. John Fisher, he did what all taxpayers who are frustrated or are not very happy are doing. He left it in the dustbin. He forgot it. He threw it away and forgot it. And then, but not the tax inspector in Belgium. On the 1st of November, he sent a reminder. And well, the same fate happened to the reminder, also in the dustbin. And then it became.
In the meantime, he kept on doing his trade in Belgium, right?
Oh yeah, sure. He continued. He thought all the tax people, they're out of mind. Well, it became a procedure, a mutual agreement procedure at the end of the day between the Dutch tax authorities, the Minister of Finance, and the Belgian Minister of Finance to find a solution. Because the Dutch tax inspector took a completely different position. He said it is not a permanent establishment in Belgium. So John Fisher is completely right. He is only taxable in the Netherlands. The van from which the eels are sold cannot be considered to be a permanent establishment. because of the fact that the eels are sold from distinct places, not from one place, but from a whole series of distinct places. And that is not where we are talking about in respect of the definition of firm establishment. Well, I think you want now to know what the end was of the mutual agreement procedure between the Netherlands and Belgium. Well, it took 4 years because there were more John Fishers, there were more traders like this, bulk traders in Germany and so forth. So it was much more than only one case. Well, the agreement with the Belgians, the agreement between the Dutch Ministry of Finance and the competent authorities in Belgium was that as long as John Fisher sells his eels on the same marketplace in Belgium on the basis of a license of the local community, then it is a distinct place. If he sells the eels from different places, well, then it is not a permanent establishment. If there's a license to sell on a marketplace eels, well, then there is a specific location. You cannot go, I think, also in Italy. I know Italy likes very much markets, and so you find them in all over the place. But you cannot go to a market without a local license, a license of the local community. So it is in the Netherlands and in Belgium. So that was the outcome of the procedure. So more distinct places, well, is not part of the definition of permanent establishment.
So, Wim, if I may interrupt you,
Yes.
perhaps you will touch this argument later on, because there is so much to talk about the PE that we are just scratching the surface. But in your real life case, you mentioned that the final decision was not taken by the judiciary as we would have expected. I think that the students and even myself would have expected John Fisher to challenge the audit, that reassessment in front of a Belgium tax court, in order to have his case cleared. But you mentioned that not in this situation, but in this situation, in all the situations similar to this, the treaties provide, well, a kind of a forum, a kind of arena where not the judge, but the two tax administration can talk to each other in order to find a solution.
Yes.
Which is not a judiciary procedure, right? It is not.
No. The mutual agreement is what it is. It is an agreement. And you cannot compare. No, let us compare a mutual agreement with a court decision. Well, a mutual agreement is an agreement. A decision of a court is not an agreement. And policy elements play a role in a mutual agreement, can play a role in a mutual agreement. They are more flexible in a mutual agreement, more flexibility in a mutual agreement. In a court decision, well, that is based on arguments and on a reasoning. So there is a big difference between a court decision is based on, let's say, on a legal logic, and a mutual agreement is based on the logic of an agreement, and that is something that is completely different. Well, John Fisher could have gone to the court. He could have gone to court in Belgium. He did not do that. He went to the Dutch tax authorities. He cannot go to his tax inspector. He has to send, in the past, he had to send a letter to the Netherlands Ministry of Finance, and then the Netherlands Ministry of Finance invites the tax inspector of John Fisher for information. And if the argument is strong enough, then the argument is taken over by the Minister of Finance and sends a letter to the Belgian tax authority, Ministry of Finance, there they have never heard about the case. They go to their own tax inspector, invite the own tax inspector for information, and then if the Minister of Finance in Belgium thinks that it is that the case is sufficient strong from the Belgium side, then the minister answers the Netherlands Minister of Finance. So it is a lengthy procedure. If at the same time John Fisher would have gone to a Belgian court, then the mutual agreement between the Netherlands and Belgium would be suspended. And there's a very good reason for that. Assume that the Belgian tax court comes to the conclusion that that there is no PE in Belgium. That means that Belgium cannot tax. And assume that the mutual agreement between the two states would come to the conclusion that there is tax in Belgium, that Belgium has the right to tax. Well, then you sit with a situation that according to a court decision in Belgium, the tax inspector in Belgium cannot tax, and according to the mutual agreement, he has the right to tax. Then there is no tax at all. So to avoid that kind of situations, the mutual agreement will be suspended until it is known what the decision is of the Belgian court. In Belgium, the decision of a court and a judicial decision is of public order. The tax inspector cannot deviate from that. So in the Netherlands, it is different. In the Netherlands, a decision of a court means that the tax inspector cannot tax more than that. He has the right to tax that, but he's also allowed to tax less. He can even go to zero if needed, but that is not the case in Belgium. So all these things play a role in such a situation.
Maybe just out of curiosity, what about enforceability? In such a case, we've seen that, like from the Netherlands perspective, I mean, since the tax authority in the Netherlands, they said, no, we do not have a permanent establishment in Belgium. And the Belgian tax authority, at the opposite, they would say, yes, we do. And then we do have a taxpayer basically ignoring, okay, the Belgian argument. How could, hypothetically, Belgium react to this kind of position from the taxpayer, the Dutch taxpayer, and the Netherlands itself from an enforceable point of view? Are there tools?
No, that is another thing. The difference between a court decision and a mutual agreement. The taxpayer can play a role in the procedure in court. He's a party. Sure. Not in a mutual agreement procedure. Yeah. He can only initiate a mutual agreement. He can send a letter to the Netherlands, to the Netherlands Ministry of Finance, or in the new situation also to the Belgian. The things are changed a bit, but to the Belgian tax authorities. But that is the only thing that he can do. He can initiate a mutual agreement procedure, and then it stops. So it can happen that he does not hear for years anything about what is happening between the two tax authorities. He has no right to have copies of the correspondence between the two tax authorities. He does not play a role in that.
Political, we may say. Of course, it's not like the correct way to say that, but it's very discretional also.
Yeah, I know that I've seen hundreds in my time, hundreds of mutual agreements. I know that there's a very negative idea about mutual agreements, that governments are playing cards with these things. But that's not the case. In my opinion, a mutual agreement is more flexible offers more possibilities for a taxpayer in a certain way than a procedure for court. But it takes long, and other policy elements can play a role. But the position of a good taxpayer is never neglected. That is what I have seen on my side in all those years in the Netherlands Minister of Finance. Yeah, I could give you, well, let me give you, if you like, a concrete example.
Absolutely. Absolutely.
Yeah, it's also for my, it had to do with Italy. I was called in a year in November by a lady. She was called in the end of November, and she said by phone that she would retire. She would become in February 65. She had lived 30 years in Rome, and she was a teacher there, and she had income, and her husband was Dutch. He was some years before he passed away, and she had decided that the moment that she would retire, she would go back to Amsterdam. They had an apartment there, and she would live from the 1st of March. She would be a resident of the Netherlands. But she asked me to take action because she was completely sure that she would not get the 100% of her pension. She would get, according to Italian domestic law, only 70%, 30% would be withheld. And she asked me to take already action. I said, well, that is not the way it goes. You must have a direct interest. There is a general rule, also I think in Italy, quen d'intérêt, quen d'action. You have only an interest if there is no direct interest, you cannot go to court. So I said there, well, the moment that tax is withheld, if your first payment, call me again. Well, the end of March, she called me, said, I had only 70%, as I told you before. So I sent a letter to under the mutual agreement to the Italian Ministry of Finance. Article 18 of the 4,000 tax treaties and for the models there's a one-liner. Today it is a bit more complicated since after the last update of the OECD model. But for many years it was a one-liner, and the one-liner is that pensions are exclusively taxable in the resident state. So from the 1st of March, she was under the tax treaty, under Article 18 tax treaty between the Netherlands and Italy. She was a resident of the Netherlands and exclusively taxable in the Netherlands. No doubt about that. All of us, we could read that in 1 minute. And we concluded in 1 minute. I'm not going to say anything in the negative about Italy or so, but it took 5 years to solve this matter. And then the conclusion was that we were right, that the exclusive right to tax was in the Netherlands. And so.
Okay, but for the period of these 5 years, they only paid her like 70%?
Yes, that was a problem. And then they could refund only the tax withheld in the last 6 months.
The reimbursement, yeah.
Can't you go against it? Like, can you accord damages?
She could have filed an appeal to the Italian court.
Yeah.
Because the problem we are discovering now that one of the problems we have in international tax law is that we have sophisticated treaty networks, but there is no court. There is no supranational judicial authority that can attribute the power to tax on one country or to another. So if you are, I don't know, in the future, you will be in the business, assisting a company from Hungary, from wherever you are from, planning to have a trade or a business in another jurisdiction, Well, you have to inform your company that they will be exposed, so to say, to the judiciary of the other country if they have a problem. And of course, if in the other country you have a robust and solid rule of law, not a problem. But if you are investing in a country like in a faraway jurisdiction where the judiciary is under the spell of or influence of other authorities, then you can have a problem because the treaties are very well written in most of the cases. But in terms of
But in this case, yeah, in Italy, the terms are of public order. So the tax inspector and also the minister could not make any move. And all this is fair enough. There's no doubt about that. And then you ask me, what is now the beauty, if there is a beauty of the mutual agreement? Well, this lady was left alone with let's say, with too much tax in Italy that could not be refunded, and it was a good taxpayer. Well, we thought, okay, if it is not possible through let's say from Italian side, we do it on our side. So we gave a credit instead of a credit, and that meant that, well, we took the balance in the Netherlands.
Okay.
It cost our fingers that our parliament was not informed of this kind of thing. But for good taxpayers in a mutual agreement, you can do something. So this is only to say there is much negative information about mutual agreements, but it opens also the possibility to be flexible.
So I didn't get that. So
Yeah.
reimbursed for your losses?
from the I understand that if I'm correct, the Dutch government like compensated her for the taxes that she paid in Italy. Is that correct?
Yeah.
It's something that Italy wouldn't do.
I think we should speak Netherlands.
Yeah, it sounds strange for a moment.
But don't speak about that. But it's a long time. Let's say it's.
Okay.
But only to show you that the mutual agreement is an instrument that gives some flexibility to tax authorities, and it has more flexibility than a court, than in the going to court. On the other hand, taxpayers don't play a role in the procedure. They are outside of it. They don't know what is happening for years. Yeah, we were used. I don't know, and I think other countries would do perhaps the same. But in the past, we were used to inform every year or so that we were not forgetting the case, that we're still in discussion.
And I have another question, if I may. You just said that to finalize the procedure, it took like 5 years. But is this because you meet like once a year, or is because normally, not in this case, but generally speaking, maybe the counterpart is not that involved, engaged, or keen to find a solution? I know that every country is different. But
it was like that I talk about the 80s, and many countries, they were very slow in the mutual agreements. And I can give you more examples. Mutual agreements of 20 years existed. And we had mutual agreements that took 20 years. 20 years. Well, what is a reasonable period for a mutual agreement? That is 2 years. And why 2 years? Well, in 1995, there was entered into force an arbitration convention between the European countries, and the arbitration was made possible after 2 years. If the mutual agreement in a transfer pricing case would not be solved in 2 years' time, then there was the possibility of arbitration. The funny thing was that after 95, nearly all transfer pricing cases in mutual agreements were solved, because no government wanted
Do the arbitration.
arbitration. Yeah. Yeah. So an indication to solve a mutual agreement, 2 years. In this case, I think, yeah, it could have been done. Yeah, it could have been done earlier. On the other hand, you should realize that part of the Italian tax policy is in Article 25, the second sentence of the second paragraph is not included. Italy is not really inclined to accept the second sentence of the second paragraph of Article 25, in which is stated that notwithstanding internal time schedules, the result of the mutual agreement will be implemented. Italy is not in favor of that specific provision. I know that because I negotiated the treaty with Italy. It was a hell of a job to get a reference to that in the protocol. Italy was not prepared to accept this provision just for this specific reason in the treaty, and we have tried to find a solution in the protocol with a more general formulation. But yeah, I don't know what the situation is today in the Italian tax policy.
Well, I don't want to make the discussion too much Italian because this is a international class, but I've been told that tax administration in Italy, tax agency had made a remarkable improvement in terms of timing, in terms of openness to international relations. Well, there's actually a new generation, several new generations of tax inspectors that are way, I don't want to say better, but say different from the one that were maybe in the 80s and the 90s. At that time, probably suspect prevailed. Well, and fear as well, because, if you are the tax inspector and you enter into a mutual agreement procedure, you expose yourself. I mean, there could be somebody else in the tax administration telling that, well, that guy has entered into that agreement, but he was like kind of connection with others. He didn't behave very well. He didn't say, or he didn't play all the cards that he was supposed to play. So we say in Italy that only if you do nothing, you make no mistake. And so many people took that literally. But now, they are serious, but
it was in the 80s and the 90s, beginning of the 90s, it was a different world. And I have seen countries where you never got an answer. You sent a letter to a country, to a tax administration. You never got an answer. You could send reminders, but it didn't work. So it is an Italian example. Perhaps you think 5 years, but it was not an exception. And Italy was, in this respect, in this specific situation, other things went well. Let's be very clear.
There are lights and shadows, shadows and lights.
But this was a very specific situation where the solution was very simple, and for one reason or the other, he didn't get an answer. Yeah.
I never really get into this topic, so this mutual agreement on taxation is kind of a new thing for me, and I'm just wondering, how big of a legislation is it between two countries? How many mutual agreements could a country have? Is it something that humanly can be followed up on, or is it the job for a ministry by the numbers?
No, it is always, the numbers. Well, nowadays, I left the ministry in 91. The mutual agreement procedure, is modernized and is also more under control. As far as I know today, countries have to make clear every year how many mutual agreements they have on the shelf dealt with, and how what they have as an on their list. And in the Netherlands, in my time we had every year. That's 100, 60 to 100, the difference. Today, I'm not familiar with the figures today.
Can't even imagine.
In Italy, it's in a matter of hundreds.
Hundreds.
How many? I didn't check the data, but according to the report, 200 or 300 per year, or even more. Now it's much more automatized than in the past. In the 80s and the 90s was kind of revolutionary, like never done before thing. But now it's almost routine because, as Professor Wijnen pointed out, within the European Union and only for European Union partners, we have also directives that provide arbitration procedures or binding rules in this respect. And within the European Union, we have the Court of Justice, which can intervene if something goes south and goes bananas, or call it as you like. So in the old continent, we have a robust framework that facilitates or accelerates that kind of mutual agreement procedure that actually they depends on the goodwill of the people. Essentially, we go back to that because there is not a clear procedure. It depends on the tax inspectors you have. It depends on the level of education. It depends on the commitment of the government. It depends on also political guidelines that you have. Why not? On several factors. But within the EU, we have this kind of framework that is quite efficient. It works. Outside the European Union, and I mean United States of America, I'm not talking about exotic countries, US, China, Brazil, Japan, Australia, like important partners, I guess, for Italy, but also for the Netherlands.
Sure.
Well, scenario is far from perfect. What the OECD can do, I mean, the International Organization for Economic Development, the OECD has no binding power in the matter. But one thing that they have done, they are doing, they shall do, is this kind of peer review or transparency initiatives. If you go on the OECD website, even now or later maybe, you can find a lot of reports on the peer review between countries. So they just say they publish data about the performance, the Italian performance, the Swiss performance, the German performance, and that's not decisive, but it's persuasive. If your country is on the list saying, well, Italy has only finalized 20 mutual agreement procedure, while Spain has finalized like 300, well, it's an impact. It has an impact on your reputation.
Sure.
And sometimes it works, sometimes it does not.
No, but that's the way it is.
Yeah, normally like soft law, how can we call it? Like recommendations, nudge, or whatever. They succeed where binding rules fail.
Yeah.
That is the point. Yes, indeed. And it's also true for individuals, but also true for multinationals. Yeah, right. The same thing. I mean, companies and in the case of permanent establishment as well. Indeed. Other questions or comments, feedbacks from your side? Shall we do a 5 minutes break, or if you have questions or comments, it depends your target.
Well, I heard, if I may, a very pretty funny story about pipeline case law, where I'm not sure, it's pretty recent probably. We can discuss it after the break as you prefer, of course. But if I'm not mistaken, like even a pipeline under the ground was considered to be a permanent establishment.
In the relation between the Netherlands and Germany.
Yeah, exactly.
Because it is only in pipeline, and there was no employment.
Yeah.
It was only
Just so fixed place of business. But then in the application and the material application, there are some extravagant, we may say, cases where even a pipeline under the ground without personnel, without staff, without building was considered to be still permanently established, justifying taxation and found tax. So I found it interesting.
Yes. Yeah. Klaus Vogel made some remarks about that.
Yeah.
That's really interesting.
Yeah, it is. Well, pipeline is important, but now think about the cable providing data. They keep on laying like how to say in English, optical fiber data to transfer from the United States to Europe. And most of those cables are actually operated by private companies. From time to time, you see on the newspapers like Google or Amazon have their own cable transmitting or transferring data from the US through Greenland, Iceland, and then to Europe. And well, and if you consider those, then the North Stream and the South Stream pipeline from Russia to Europe, that was another example of those infrastructure. But then another question that I always had was, how can you attribute a tax base to several permanent establishments? Because in the case of the fishmonger, the John Fisher, he went with the lorry with a small truck to the Belgium, and maybe he sold, I don't know, 100 eels for a few euro each in Belgium. So from a practical point of view, you could calculate the amount of income that he made or created, originated in Belgium. You can also allocate some costs, maybe the fuel costs or whatever. But in the case of those big multinational where you have pipelines or cables, going through your territory, how can you allocate taxable income in that case? How can you say that, I don't know, the company X has made that amount of profit in that jurisdiction because of that cable? Isn't there a lot of discretionary power by the tax administration or not?
Yeah.
Yeah, it could be. Yeah, that's the point.
Maybe it's different with the pipeline. They can calculate where they transport which amount and where it's used with use of the pipeline, it's a cost. But internet is a good question.
Internet, it is absolutely. Or providing data.
Transmitted, not just the opportunity to transmit data, but the actual data transmitted is.
Indeed, the bandwidth that you use in order to transfer it. And maybe in the future, but again, I have never done any study in this respect. So please take this as a stream of consciousness. If you think about Starlink and Starlink alike companies, that's not the only one, but all those that provide connection from the satellite. When I was younger, years ago, there were people that used to. I also found a book, Taxation of the Space and Taxation, something like that. And that kind. I said, well, this is a kind of book that you publish only to sell copies because it's sexy, like those that write like taxing artificial intelligence, taxing robots. What is that? Nonsense. That was years ago. But now, if you think that like a company like Starlink or the other competitors, I don't want to make things too much personal, but Starlink, they provide you a service without actual no PE in the country. Everything is up in the cloud.
Yeah.
So
They can locate. It can be established in a low tax jurisdiction and sell all these goods all over the place in the world through internet.
Indeed, that's a point.
And then there's no
I
PE
would
anymore.
think it's similar, for example, with the cables, which are placed in the sea, like in the place of no country. So in a similar situation with the space law, and I think that there is going to be some case law and some new laws about this, but at the moment it's not enough, like to make any conclusion.
Also heavily reliant on space treaties. Space treaty, I don't know, there is a few or
I think that there are not enough of them. Like
Probably.
very thin.
I'm not an expert in tax in space that kind of treaties, but space treaties.
Everything is about everything on the principle of shared, like human heritage.
Mm-hmm.
Everything that is in the air, in this space, I guess, something like that. I have only like a small class, but there is a few teacher in Alta who
are discussing
this, yes, few books.
That is fascinating. In the case of the sea, well, this is the future. In the case of the sea, maybe from your studies in international law, you have studied the exclusive economic zone, which is the part of the surface under the water whose exploitation belongs only to the states that is in front of it. So you have, as you may remember from your studies, you have the territory of your land, then you have the national waters, the oceans or the sea in front of it. Then if you go beyond that,
200 miles.
Exactly. You have the exclusive economic zones that allows the state to exploit like fishes or if there's oil, of course, or natural resources over there. So I guess that if it's fascinating from a tax perspective, we could consider the exclusive economic zone as a territory of the state for PE purposes. That's another point. Thinking about oil rig that you may have in the sea. It's fixed, yes. It's a place of business, yes.
Yeah.
That's another very interesting or fascinating point to debate. Okay, other comments or feedbacks? I think we have to go away from here at 6:30, so it doesn't make a lot of sense to have a break now because
No.
very soon the guy at the reception will knock at the door asking us to leave.
Yeah.
So yeah, if you haven't got other questions, haven't? Yeah, absolutely. So that's it, Wim.
Okay.
Thank you
Well,
very much for.
Thank you. Yeah, thanks for this fantastic audience. Well, as a last word, I would say, yeah, there was somebody yesterday who said, well, is it not time for tax authorities to forget them? Is it not? Yes, I would say in general, you could think of the two fiscal rule, the two rules of fiscal dynamics. The first rule of fiscal dynamics is that all taxes are avoidable. These two rules of fiscal dynamics are based on the rules that Einstein found for his laws. The second rule of fiscal dynamics is that every order turns into chaos. So whatever you do in tax, it turns, in the end of the day, it becomes chaos. Well, for two reasons. The first reason is that society changes. That is not tax laws have to adapt to the new situations. The second thing is that they decline by the use of taxpayers. They try to avoid. So at the end of the day, you have to find something new, new rules. If you compare tax law with, let's say, civil law, then civil law is a completely different animal. Civil law started some 6,000 years ago, and then you go to Sumerians, you go to the Egyptians, Greek, Roman law, yeah, your Justiniano, and well, every generation placed a stone in this fantastic castle. If you say, well, civil law is a castle with all the tints and a bridge and all the towers, beautiful, it's shining on the horizon. And then tax law. Tax lawyers make also castles, but different castles. They don't have much time. They make sand castles between high and low tide. And they know, because of these laws of fiscal dynamics, that when tide comes, it will destroy the castle. You can defend it for a certain period of time, but at the end of the day, it disappears, and you have to make a new castle. So also tax lawyers make castles, sand castles, but the best there are on earth. So we are like civil lawyers, but different, more practical and more based, and let's say, yeah, in a daily way. We are practicing. We are very, very practical. So yeah, in the end, the only thing that I can tell you after so many years, that international tax law is, let's say, is an is very interesting and joyful as long as you don't take it seriously. It is that's the only thing I can say.
Thank you.
Thank you very much. Thank you, Martin. Thank you. Okay. That's
Okay.
it. So we can stop here. Terrific.